Welcome back to the Law of Journalism and Mass Communication, Chapter 6. We are dealing with privacy and the protections, and we have gotten all the way to privacy and data collection in our outline. The authors in this last part of the chapter are trying to address privacy concerns that the public has, especially in light of new technologies such as computers and the internet and smartphones. The authors talk about the ease of data collection and the lack of privacy and the lack of protections that are put in place for consumers and the public. They discuss the FTC and their role in protecting consumers and enforcing federal privacy laws. They talk about threats to individual privacy with marketers and data brokers and businesses that amass personal information about individuals. They talk about apps that can track people and collect that information. And they talk about security breaches. And they talk about problems with there being a lack of transparency with internet companies where the public and individuals have no idea as to what's being done with the information or how it's being collected, and there are little, if any, protections for individuals and their privacy. Current federal and state privacy laws do not sufficiently protect American consumers, according to the FTC. One of the things that the authors point to is data brokers who collect and store all this information that's personal concerning individuals. It covers pretty much every U.S. consumer and all of their transactions, everywhere that they go on the internet, everywhere that they travel in the real world that is tracked by their apps and by their cell phones, and they sell that information to other organizations. The FTC says that none of the 9 major data brokers go to the consumers directly to get this information. Instead, this is quietly collected from public and private sources, both offline and online. Now, this area of law can be considered relatively new in that it's dealing with the development of the internet and the technologies that underlie that. There's a case that the authors point to from 2016. It's Spokio, boy, I hope I'm pronouncing that right, versus Robbins, which is a lawsuit that tried to hold an internet search company accountable for information that was incorrect and that was passed on to other people, allegedly causing harm to the plaintiffs in this case. This was a class action lawsuit, which is a collective lawsuit where you have multiple plaintiffs all in a similar situation trying to sue in order to correct a wrong. In this case, they were using the Fair Credit Reporting Act, or the FCRA, alleging that there were errors in the credit report. Now, the Supreme Court ruled against the plaintiffs on this, saying that they didn't have standing to sue because they weren't able to fulfill part of the standard for the lawsuit. They couldn't demonstrate harm or damages. For many legal experts and privacy advocates, the decision on this was vague and kind of unsatisfying. The authors go on to talk about the Video Privacy Protection Act, which is an older statute that was put in place back in 1987, and how in the wake of the Spokio case that was decided by the Supreme Court, there's kind of a vacuum that's left there, and so lower courts have tried to use an older law and interpret it in order to apply some protections. They're extending the use of this law to newer technologies. So this goes towards disclosure of subscriber information to third parties. And again, the courts are split on how this is to be used, and the Supreme Court hasn't taken on a case that's like this in the privacy realm. Now, the Supreme Court has made other decisions on electronic privacy. With these 3 cases that are discussed in the chapter, City of Ontario versus Kwan, the United States versus Jones, and Florida versus Tardinez. And again, I'm hoping I'm pronouncing that right. The courts are applying existing standards and existing precedents to current technologies, newer technologies that are coming out. City of Ontario versus Kwan goes towards the expectation of privacy in the workplace. If you're using work equipment in the workplace, that belongs to the employer, and so there's no expectation of privacy under that setting. In the U.S. versus Jones case, they found that it was a violation of search and seizure of Fourth Amendment rights by mounting a GPS monitor on a motor vehicle. And in the Florida case, the court held that there are privacy concerns and that there are protections that are in place for individuals when the authorities want to search their cell phones, because there's so much individual data that is on these devices. The authors go on to say that this area of law is going to continue to develop, and the courts are going to be involved in deciding cases that deal with privacy. And they also talk about how Congress and state governments are developing legislation to help protect individual privacy, but the response to the needs in this area have been slow and have been inadequate. All right, that winds up Chapter 6.